All right, let's talk about something you hope you'll never need, but absolutely should understand. Indian motor accident law. We're going to break down this complex world and make it simple. So let's just dive right in.
It's a horrible situation, but it's the very first question that hits you, right? Who is responsible for this? The answer, well, it's not always so simple. The law is actually built on a really fundamental choice about blame, about responsibility, and about getting people relief when they need it most.
And at the very heart of India's Motor Vehicles Act, you've got this core split in philosophy. Does somebody need to be proven wrong for a victim to get help? Or should the number one priority be immediate support, no matter who was at fault?
And this shows you the two sides of that coin perfectly. On one hand, you have the fault-based system. This is what you might call the blame game. You've got to go to court, you have to prove that the other person was negligent. But on the other hand, you've got the no-fault system. Think of this as a social safety net, making sure victims get some money quickly without getting trapped in a long fight over who did what. It's really a choice between individual justice and immediate collective support.
So, what's really important to get here is that the law doesn't force you down just one path. It gets that sometimes the need for immediate help is way more important than the long, drawn-out process of figuring out who to blame. And that choice you make, it shapes the entire process.
So how does this all actually work in the real world? Well, the Motor Vehicles Act lays out three very distinct legal paths you can take to claim compensation. Just think of them like different routes on a map, each with its own speed, its own challenges, and its own final destination. Let's break them down.
First up, we have Section 140. Let's call this the express route. This is your safety net option. It's designed to get a fixed amount of money to victims or their families as fast as possible, totally bypassing that long court process of proving who was negligent.
Next, there's Section 163A, which we can call the formula route. Now, this is a pretty clever middle ground. It also avoids a full trial, but instead of just a simple fixed amount, it uses a government formula based on the victim's age and income to figure out the compensation. It's a more structured but still faster way to get a settlement. And finally, you have Section 166, the full trial route. This is the classic legal path. Here, you have to prove the other driver was at fault. Now, it's a longer road, it's more complicated for sure, but it also opens the door to potentially much higher compensation because the amount is decided by the court after looking at all the facts.
Okay, let's break this down because this is where you can really see the trade-offs. Look at the rows. For proof required, notice how negligence must be proved only shows up for Section 166. Then look at time. The no-fault and formula routes are obviously much quicker. But then you get to compensation, and you'll see Section 166 is the only one that isn't fixed or based on a formula. It could be higher. So you're basically choosing, do you want speed and certainty, or are you willing to invest the time for a potentially larger court-decided award? And when we're talking about that express route, the numbers are serious. Thanks to a 2019 update to the law, the fixed no-fault compensation for a death is now 5 lakh rupees. That's a huge increase, and it's all about providing more meaningful, immediate relief.
And is the same idea for a really serious permanent disability under that same no-fault rule. The fixed compensation is 2.5 lakh rupees, and again, you don't have to prove fault to get this amount.
Okay, so that's the theory. But how does all this actually stand up in a real courtroom? Let's take a look at a couple of landmark cases that have really shaped how these laws are used today. This quote from the Ishwarappa case, it just says it all. The court made it crystal clear that Section 140 exists for one big reason: to help people fast. It's all about being victim-friendly. But that raises another question, doesn't it? What about the other path? What happens when proving fault is just incredibly difficult? Well, this brings us to this really fascinating legal idea that helps solve that problem. It's called res ipsa loquitur. Sounds super fancy, I know, but the idea is actually very simple and powerful. It means the thing speaks for itself. Basically, some things are so obviously the result of negligence that you don't need a smoking gun. The event itself is the proof. And you won't find a more powerful real-world example than the tragic case of the Chandni Chowk clock tower. You have an 80-year-old landmark, owned and maintained by the city, that just collapses. Several people died. The families of the victims sued the municipal corporation, saying, hey, you failed to maintain the structure properly. And the Supreme Court's verdict here was a perfect example of applying res ipsa loquitur. The judges basically said, look, a massive 80-year-old clock tower doesn't just fall down on its own.
The very fact that it collapsed spoke for itself. That alone created a presumption of negligence that the city just couldn't argue against. They were held liable.
So a big question is, who can actually start this whole process? The law is pretty clear on this. It can be the person who was hurt or the owner of any property that got damaged. If the victim sadly passed away, their legal heirs can file, or an authorized agent can act for any of these people.
Okay, let's pull all of this together into a final essential guide. We're going to boil this down to the key numbers and the key steps you absolutely need to know.
You know, the law even has a plan for the absolutely horrific scenario of a hit and run, where you can't even identify the driver at fault. In those cases, a special government fund provides 2 lakh rupees for a death and 50,000 for a grievous injury. It's a critical backup for the most vulnerable victims out there.
So what does the actual process look like, step by step? Well, after an accident, the first thing you do is file a claim. And you don't do this in a regular court. You go to a special body called the Motor Accident Claims Tribunal, or MACT. There, you make your choice, the express, formula, or full trial route. The tribunal then investigates and makes a decision. And if you're not happy with it, you can appeal to the High Court, but you've only got 90 days to do it.
So let's recap the big stuff. Remember, you have 3 main paths. Section 140 is the no-fault express route for fast, fixed relief. Section 163A gives you a faster, formula-based settlement, and Section 166 is the full, fault-based trial that requires proof but could lead to a bigger award. All of these cases are handled by special tribunals, and the entire system only works because of mandatory third-party insurance.
And that really brings us to our final thought here. The law is designed as a system of choices, right? A balance between getting immediate help and the long pursuit of what might be considered full justice. It provides a safety net for victims of road accidents. So the real question to think about is that net strong enough?